Hello everyone. Good afternoon, good evening, and good morning to those who are joining us from the United States. Um, so this is our second webinar in this series. We did the first webinar in January. So let me just take you to the slides, and we are going to talk about GDPR and e-commerce. So all of you, I think most of you already know that GDPR is just about to come. So it's next month, only a few days left. A lot of people say that the GDPR is starting next month, which not exactly true because the data protection law or the GDPR has been there, but from next month, they are going to reinforce or enforce it. So that's why we have this discussion today, and we will talk about specifically how the businesses in e-commerce um, are being impacted with this new regulation, and what are we doing and what other companies are doing. So I have so today in the panel, it's myself from my name is Aman Sood. I'm from TMotions, and I've got my partner Rustam Roy he's the co-founder and CEO of Legalistic. Rustam is the legal person, so you will get to know a lot of the legal aspects of GDPR from him. Um, I'll just give you my little introduction, and then I will leave Rustam to introduce himself later when he will be interacting with you. Before I do that, I just want to say that we have close to 70 people joining this webinar. So it will be really difficult to get questions and answer all the questions. So I would suggest that you can type your questions in the control panel of your GoToWebinar, or you can send us the questions later through email, and then we will be answering all the questions. But I would suggest that and prefer that whenever you have any question, uh, please just type, and toward the end, if we still have time, then we will answer all these questions. So I'm the owner and CEO of TMotions Global Limited, which is a software development company, and we do a lot of work in e-commerce. We build e-commerce applications, customized e-commerce applications, and we are one of the gold partners of nopCommerce, which is the preferred platform to build e-commerce applications. It's an open source platform, and we have been working with nopCommerce for many years, and have been building a number of e-commerce applications using nopCommerce as a technology. Um, so in the agenda today, we'll talk about three things basically. One is just about the GDPR, and that's what Rustam is going to do, the first part of this presentation today. And he will talk about, he will mainly focus on the legal aspects of the legal basis of GDPR, and because he's expert into that. And then we together will talk about GDPR and e-commerce together, how GDPR is going to impact or is impacting the e-commerce businesses, and how we all are being prepared for this. And then in the third section, I will talk more about the plugin which we have developed for nopCommerce, specifically for the nopCommerce, which is the platform. Most of you probably are using it, and I'll do a bit of a demo. But that plugin is available on nopCommerce Marketplace for more than 2 months now, and hundreds of people have already downloaded it, and I'm sure most of you are or some of you are using it. So that's roughly the agenda for today. So I would now get Rustam to do his presentation. I'll just enable him to share his screen with you. Rustam, you're there?
I am there, yes, Saman. Thank you.
Okay, great, thank you. So what I'll do is I'll make you a presenter, and you can now take over and do your bit, your slides, and talk about the legal aspects. And then once you are done, if you can pass on the presentation controls to me, then I will do the rest of it.
Yeah. Can you see my screen?
Yes, I can see your screen.
Perfect. Right. Good afternoon, everyone, from sunny summary Britain, wherever you're dialing in from. Thanks, Aman, for the intro. I will very briefly introduce myself to you guys, and then we'll step right into GDPR. Let me just get this going. Right. So what is Legalistic? I'm basically an independent commercial legal consultant. I am a English qualified solicitor, and I've got about 16 plus years experience in IT and IP law. So working on anything and everything that's contract based, really, including procurement, outsourcing, software development, licensing, supply chain work. And of course, as a result of that, not escaping data protection. So I started being involved in data protection under the current regime 5-6 years ago as part of outsourcing. And obviously, when the GDPR was on the horizon, we all had to start thinking about what the changes are. And I've been operating a consultancy for a few months now. I've just been dabbling in and out of employment and consultancy for a bit, but I'm now a consultant going forward. We, like Aman, I'm part of the Atom Ventures group, and like Aman, I am part of the group members who are offering a digital compliance service as part of Atom's offering. So we can provide technological, legal, regulatory, and compliance advice as needed from a single point of delivery. So that's us covered. And
Yes,
what will I be talking about?
I'm sorry to interrupt you, but
That's okay.
We are not able to see your presentation. I can only see your desktop.
You can only see my desktop. Hang on, let's see if we can change that. It's always a problem when you have more than one monitor. Is that better?
Yeah. Yes, that's better now. Thank you.
There we go, no problem. So, sorry, people, this is what I was going through all this time, but then you've already heard that. So this is what I'm covering to begin with in this presentation. The GDPR is a big beast, and clearly we're not going to be going through everything. What I will focus on is what I regard to be the major changes that the GDPR is bringing about in comparison to the current data protection regime, and also some thoughts about how specifically that might impact on e-commerce. So we'll be talking about territorial scope, the direct data obligations on the data processor. We'll be talking about the legal basis of processing, sub-processors, subcontractors, penalties for breach, the accountability principle, and then DPO. Then we'll round it off at the end with just what are the steps required for actual compliance. So territorial scope, that's in Article 3. I'm not going to be sharing with you the actual wording of the GDPR, fascinating though that is. Let's just get straight into the meat of it. So I thought a good way to start the territorial discussion is to dispel one of the myths straight away, which I've heard from, I can't even forget how many people have said this to me. Oh, but GDPR doesn't really apply to anyone who's not an EU citizen, does it? So how does it work for us? The fact is, if you look at Article 3, the wording, the GDPR is completely nationality neutral. There are two triggers which determine whether the regulations apply to you, or to be quite correct, whether they apply to a specific data processing activity. One is if the data controller or data processor in respect of that activity is based in the union. And the other one is if the personal data of data subjects in the union, and that's a direct quote, is targeted. So for example, if you're in the first instance, there's some interesting consequences, for example. So the first one, you could be a non-union retailer targeting data subjects in the union, right? So you might be monitoring their purchasing behavior, you might be selling, marketing actively to them, but neither the data controller nor the actual processor is based in the EU, but you would still be caught by it. Equally, I've just come across an interesting one where you've got a group company. So you've got a group of 3 or 4 companies, one of which is in the union, others are in the US, Australia, and elsewhere. And the company based in the UK, in the union, provides intra-group services to the other group companies. So helping, they're the ones who operate invoice payments, they're the ones who operate salary payments. Even though the payments are made using local bank accounts, local currency, the actual processing activity is still happening in the UK. And that's actually not that atypical for a number of group companies, where one group company might provide what I would call these sort of shared services almost to the rest of the group. But because in this particular instance, the group company is in the union, they're a data processor, even though it's personal data from often people in Australia, Asia Pac, the US, but you're still a data processor in respect of that personal data. Now, as is pretty obvious with this territorial scope and the impact, there is a risk that if you don't follow the chain of personal data through, as in from the very beginning, where is it captured, who makes processing decisions, who does the actual processing, who is the one interacting with the end user, the data subject, you will risk not giving the appropriate fair processing notice, which is an obligation under the data controller. So going back to the example I was talking about just now with the group company in the UK, even though the GDPR applies and that company is a data processor, but the actual obligation to provide any kind of notification to the data subject is actually with the companies in Australia and the US. You have to then also be careful that you have a lawful basis of processing with this territorial aspect, because you may not actually, especially in the e-commerce sense, because there is such a diverse set of activities that all come together. When you buy something online, you need to make sure that each and every single processing activity has a correct lawful basis of processing, and we'll get to that later. And in particular, a risk for retailers based outside the EU is monitoring and adverts, which are clearly quite a powerful tool, but where you now really need to think about what do you have to do in order not to be in breach of the GDPR when you're targeting people in the EU, even though you're not based in the EU at all. Which brings us from that example quite neatly to the direct obligations on the data processor piece. Now, for those of you who are familiar with the current regime, you'll know that the vast majority, really the primary obligation under the current regime in respect of compliance, rest with the data controller. And I'll just briefly talk about these two concepts because I still think there is a lot of confusion about what that actually means. A data controller effectively is the entity that makes decisions about how personal data is processed. So you're the ones who are capturing a personal data and you decide, well, I think it'll be quite cool to do X, Y, Z with this data. And that's what the sort of the processing activity in respect of which you have to be in compliance. A data processor is the one who processes personal data on instructions of the data controller and doesn't make any independent processing decisions. So if you're a data processor, for example, and you have access to a vast amount of personal data because, for example, you're processing marketing activity, you're managing a database of marketing activity, you can't suddenly decide, oh, I'm developing this cool service. I think it'd be quite nice to market this service to all the data subjects whose personal data I have. That would be wrong because you're not a data controller. You're a data processor. Now, in Articles 24 to 43, how the GDPR has moved things along is that it has given, for the first time, a set of direct obligations on data processors. And that's in acknowledgement of the fact, I think, that over the years, it's become clear that many data processors actually carry on the substantial amount of processing activity for personal data, even though the front end, the interaction with the data subject might be a data controller entity. The real risk arises out of what the data processor does. So that's why the GDPR has moved on now and said, well, hang on, we need to capture that. And hence, this new step has come about. Now, just briefly going through, there are now obligations on the data processor in relation to sub-processors, what you need to do when you appoint subcontractors who also process personal data. you have now, as processors, direct obligations about technical and operational measures. So you no longer can rely on instructions from the data controller, but there are certain direct obligations you have. There's a record-keeping obligation on data processors as well now, a direct one. You have a direct notification of breach obligation, which is new. You are an obligation to cooperate directly with the regulatory authority, so no longer just going through the data controller, but it's direct. And what is one of the key aspects, which isn't getting a lot of attention actually in many areas, but which should, is that there is the concept of joint and several liability under this GDPR. And what this is a horrible sounding legal term, but what it basically means is that if there is more than one party involved in an activity which gives rise to liability, then the party claiming can claim either against any one of the individual parties or jointly against all the parties. So to put that in context, if you're a data processor, you can now be sued directly by a data subject in respect of a breach, and they don't have to just go to the data controller. So you have to really think about, in any contract with a data controller, you need to think about, well, what are we actually doing that we are relying on the data controller? How do we back off that liability on them now? Because we are exposed to a much greater degree now as data processors than before. And vice versa, as a data controller, you need to think about perhaps not such a huge change, because as a data controller, you always had to think about the fact that you are basically outsourcing processing activity to a third party. How do you make sure that you're covered in respect of direct claims from a data subject for activities which you're not actually doing? But the difference is you now need to think about, well, what if data processors come to me and say, I want to be covered in a much more rigorous way because we're exposed directly? How do you deal with that? And of course, the first step is to establish whether you're acting as a data controller or data processor. And one of the interesting things to keep in mind is that it is actually possible to be joint data controllers. So it is not the case that in relation to one data subject or a processing activity that there can be only one data controller. Just like there can be more than one data processor, there can also be more than one data controller. But if and many companies take the view that, it actually makes it easier for us to be data controllers because we are then more in charge of saying what can and cannot happen with that personal data. And that's a view you can take, but you then have to make sure you also comply with the more onerous obligations that data controllers have. And in particular, you need to make sure that before you start your processing activity, you tell, by way of a fair processing notice, you tell the data subjects what it is you intend to do with their personal data, and that you have a lawful basis of processing in relation to you acting as a data controller. So again, there is no one way to deal with that risk. It's a case of as a business, you need to decide what is best in order for you to manage your risk, and are you able to actually comply with the GDPR in choosing that particular course of action? So it's a step-by-step assessment. So now let's talk a little bit about this legal basis of processing bit, because that's actually a very, very big change compared to the current regime. I've used that several times. It's called legal basis of processing or lawful basis of processing, depending on whether you're reading an English source text or a European language source text, really. So just to set the scene slightly, under the current regime, the biggest source of lawfully processing personal data is still consent. Most people try and obtain consent, they give opt-outs, and it is possible to obtain consent at a relatively high level. It doesn't have to be particularly granular. Now, this has really changed quite a bit. Under the GDPR, there are 6 major grounds based on which you can process personal data lawfully. And there are 2 more which deal with special category data, such as health history, sexual preference history, all of that stuff, which is obviously requires an extra level of being careful. And then the criminal history data. I won't go into those because those are really quite niche areas and are probably better dealt with in a sort of talk or presentation on their own. But the 6 main grounds that you need to consider are consent, contract, legal obligation, vital interest, public task, and legitimate interest. I won't talk about each of these in detail because it'll just take too long. But the highlight here is that consent, which is currently the main ground of lawful processing, that has changed substantially. So consent now under the GDPR, if it is to be a lawful basis of processing, has to be freely given, has to be extremely specific, and also can be withdrawn at any time. So what does that actually mean in terms of an impact? It means that if you seek someone's consent, you have to be extremely clear about what it is you're seeking consent for. So it's no longer perhaps enough to say, we would like to use your personal data to send you newsletters. It is quite possible that regulators will take the view that actually this means that you need to set out exactly what type of newsletters and how frequent they are. Freely given, what does that mean? It means that there mustn't be a sort of quid pro quo equation there, because the tricky bit is, and especially in relation to a lot of cloud-based services and products, if they don't give you personal data, they can't actually receive the services they sign up for, right? So then you think, well, actually, that should be quite straightforward. I get their consent because otherwise, how would they get the service? But that's exactly the problem. If you phrase it in that particular way, then it's not freely given because there is a negative consequence as soon as they withdraw consent. And under the GDPR, at least, that is not correct. So you have to be extremely careful about how you use consent going forward, because you have to be careful that it is very clear what the consent is for, that you can still, that the processing activity you're engaged in, if you're contractually committed to provide it, that it's not endangered if they withdraw consent. What do you do then if they do? I'm not suggesting consent cannot be used, but you just have to think about it much, much more carefully and use it less. So a lot of people are migrating, I think, in my experience, at least from what I've seen in practice, the legitimate interest basis is going to be key going forward. And we haven't had a great deal of guidance about this from the regulator, it has to be said, which is part of the problem. But some of the key decisions that have already come out about legitimate interest show that you can use it much more freely than consent. It is easier in many ways to justify, but you have to also show that the data subject is receiving a benefit. So you can't just say, oh, for example, we're collecting all this marketing data, we're using it for our own analytical purposes because you'll get a better deal if we know what it is you're engaged in. Now, on the face of it, that is a legitimate interest, but you actually have to be able to show what is the benefit. So there was a decision recently where I believe a marketing company was told, well, what you're saying about legitimate interest is all well and good, but you're not actually providing a benefit because you're not showing these data subjects that they actually would benefit from differential pricing. So where's the benefit? So these are the things you need to think about. And contract basically is what it says. Contract and legal obligation are not necessarily the same, because legal obligation can also arise out of statutory legal obligations. So not just, or even criminal sort of law legal obligations, not just contract, whereas a contract is exactly that. It means for the fulfillment of a contractual obligation that you have, not necessarily towards them. So these all, you need to really think about what the processing activity is for, who benefits from it, what would happen if they withdraw consent, in order to decide what's the best lawful basis of processing. The key thing to remember is that the lawful basis of processing must be established before the processing activity. So if you're a data controller, this applies to you in particular, because you have to give the fair processing notice. You have to tell the data subject before you even process their data how you're going to use it. You have to document it, that's a requirement. And as I said, it must be included in your privacy notice to the data subjects. There can be more than one, and that's often a good way to do it, because if, for example, using consent together with legitimate interest, and you don't necessarily have to voice it in that way to the data subject, but you have to document it internally. You have to leave a paper trail, and we'll get to why. You have to set out quite clearly in that paper trail that our reason for, our lawful basis of processing for this processing activity are the following because of blob. And as I said, consent. Please be very careful about it. I think as an for e-commerce businesses especially, that's quite an exposure, because if consent is withdrawn, then a number of different activities could potentially be impacted very quickly. So let's talk a little bit more about one of the obligations that data processors have, which again for e-commerce has particularly strong ramifications for e-commerce and anything cloud-based. So I've copied the direct text here only because I think it's worth it. It's that frankly bizarre, and I have to say I'm a big fan of the GDPR in many ways, but I think where they really have lost the plot a little bit is in relation to how they deal with cloud-based services and products, because it just does not have any connection with reality how these operate, right? So the text literally says the processor, the data processor that is, shall not engage another processor without prior, specific or general written authorization of the controller. Now, basically what that means in practice is that if you're a data processor, as you all know, if you're involved with cloud-based services, you generally have a whole ecosystem of service or platform level contractors who work with you in relation to the end product or service, who process personal data. And unlike the very old-fashioned traditional sort of outsourcing models, you don't really employ subcontractors, sub-processors just to service one customer. That's not how it works. They work for you for the platform, they work for you for the service as a whole. Now imagine if, as a data processor, you have to seek one data controller, which will be a customer entity, often consent in order to appoint a new subcontractor. I mean, it would be absolute chaos if that's how it really had to work in practice. It would be unworkable. And Article 29 kind of reinforces that by saying any processor or person acting under the authority of the controller or the processor, you cannot process that other than on instructions from the controller. So that almost implies that if you were to employ or have a sub-processor, that there might be instances where the controller actually has to have a direct relationship with that sub-processor, which is just as impossible, because you are the ones dealing with that sub-processor as a processor. You're not going to be, facilitating a direct relationship between either an individual retail customer or even a controller if you're B2B, and that service provider who sits under you as a supplier. So, I mean, what are businesses going to do? And this is going to be one of the, from my point of view, fascinating areas to watch development of, because there is not a single cloud-based provider who is going to be giving a data controller that right. Can you imagine Amazon or Microsoft or whoever, one of the big guys, Salesforce even, giving a data controller of their data that right? They would cease operating as a business. So the various workarounds you can consider. You can either just come in there and say, sorry, that's not how it works. We're not going to give you that right. If you decide to walk away because of that as a breach, then you can terminate the contract and we'll have a pro rata assessment and you walk away. And of course, as a business, who likes to give money back? Nobody likes that, right? So that's a nuclear option, which nobody is going to be regarding as number one option. So then you have to really think about what are the various ways you can do this. And there are some ways, but the problem here is none of this has been actually subject to any detailed guidance by the regulator. And it has to be glaringly obvious to anybody that this poses a huge problem for any cloud-based platform or service. So it'll be fascinating to watch how that's dealt with going forward. Penalties. This has been in the news a lot for, understandably, because even though we have obviously an existing regime of penalties and charges, but it's nothing like what the GDPR enables regulators to charge. So in addition to powers of the supervisory authority, and what that means is whichever the regulator is that's responsible for that activity or that data subject, they have the ability to come in and say, give you certain sort of performance orders, in a sense, to tell you, show us this, show us your processing activity, show us your documentation in advance of any penalties. But then clearly they also have the right to charge up to 10,000 euros or 2% of worldwide annual turnover of the preceding financial year, whichever is higher, quite nicely. So obviously, as you know, the big guys in the e-commerce world or cloud-based services, for them, this is a big issue because even though they're quite used to pushing revenue in various ways to make sure that turnover in any particular location is low for tax purposes, but when it's framed in this particular way, it's difficult to avoid that. But then you need to take a step back also and think, well, how likely actually is it that you're going to be facing these penalties for breach? Because even going by what the regulators, the ICO in the UK have been doing, for example, since the current Data Protection Act came into force, it is actually only in exceptional cases that really heavy financial penalties have been levied. And it's usually where an entity has shown itself to be negligent or just utterly incompetent almost about various principles of the Data Protection Act. In my personal opinion, and this is an opinion only, I stress, this is likely to continue as a cultural behavior, because if you think about how much effort the various businesses in the union have to put into actually making themselves compliant, documenting, and having all these policies in place, and if you extrapolate that to, well, how much effort would it take the regulator to actually sit there and examine everyone's processes? From a purely resourcing point of view, it's an impossible task. It just couldn't happen. And I think most businesses have taken the view that, you know, we're not going to ignore it, but equally we're not going to be scared of being penalized straight away. But we do need to show that there is some work in progress, some significant work in progress that will make us compliant. So, you know, again, in my opinion, and I come from it from a very commercial, practical point of view, I think what you need to be concerned about much more than any fines is your reputation and potential loss of business. So I've been working with a number of enterprise level software licensors, and we've actually seen some contracts not being renewed or renewal delayed, because the customer entity is not satisfied with the progress that the supplier has made to show GDPR compliance. That's actually a much more of a risk than anything else. So why is all this I mean, obviously the GDPR is coming into effect, et cetera, but why is it all such a big deal suddenly? I mean, people didn't make such a big deal under the Data Protection Act, I remember. Now, this is actually, one of the reasons is this, apart from the fact that people easily get scared by the risk of high penalties, no matter how unlikely it be. But this Article 5, Paragraph 2 is interesting, because it says that the data controller, you have to be able to demonstrate compliance. And what does that actually mean? That for the first time, there is this real requirement that you have to have a proper paper trail in place. You have to be able to show, for example, in the case of an audit, you've got to be able to demonstrate why you're making, or you've made certain processing decisions that you've made. It's no longer enough to just, you know, decide this with a few emails and that's it. So, you know, as I've said here, documentation is mitigation, because even if you've found to be in breach, or even if you have an audit as a supplier, for example, one of your customers performs a data protection audit and finds, you know what, you're processing in breach of our agreement, but any fine you may be subject to will absolutely be mitigated if you can show the regulator that you have actually you've done a sort of thinking about this, you've had a thought about this, and that means documentation. You've got to have a paper trail. So finally, sort of towards the end, DPO. This is, again, if you look at even LinkedIn, for example, every second post almost these days is about somebody offering DPO services. And, you know, I can understand that, because it is suddenly a technical area of expertise that is lacking, because there's never been this much of a volume need for that level of expertise. Now, Article 37 lays out certain criteria which determine whether you have to appoint someone or not. But the point I would make is that, leaving aside the strictly legal requirement of whether you have to have one in place or not, you should also think about reputation. Often, especially on an e-commerce platform or any service provider that handles a large amount of personal data, or a data controller that interacts with the data subjects, being able to say that if you have any questions, please speak to our data protection officer, Blob, shows that you're taking it seriously. And I've worked with a few companies now recently who, even though they were not under a legal requirement under Article 37 to appoint a data protection officer, have taken the decision to hire one, even if it's a part-time one or a virtual one, just in order to be able to show their customers that they are taking this seriously. And it also means that you have a source of, you have a resource that basically has this knowledge and who you can rely on to interact with a regulator and fulfill this requirement. The key thing to remember is if you appoint a DPO, remember that it's not just a title, and that's really very, very important. The whole idea of appointing a data protection officer is that this person has to be able to make an impact and has to be given real powers to coordinate the data protection effort. It doesn't mean that the data protection officer has to be in charge of how your company conducts business. And I have seen this. For example, in France, last year, we were negotiating with a client a number of contracts on a software basis. And, culturally in France and in Germany also, data protection is a big deal. And I get that, I respect that. But where it got really interesting is that some of the French data protection officers were powerful enough in their companies to almost scupper deals because they weren't entirely satisfied and were unwilling to take a commercial view. So somewhere in between is where it has to come in, because business has to go on. You can't stop business, but you have to make sure as a DPO, or if you're appointing a DPO, you have to set the remit out so that there is a balance between making recommendations and being able to enforce those recommendations. So what do you do to get to compliance? And this is from beginning to end, just some brief things. If you haven't done anything, this is what you can still do in order to get somewhere, at least by the end of May. And it is possible if you're not a huge multinational business with many offices in many jurisdictions, it is possible. So the first step is data mapping. You have to actually map out, even by using a simple Excel spreadsheet, the different business processes, departments, list the activities, what personal data, what are you processing it for, and who are the suppliers from that activity. Talk about where the data is stored, and in particular where the processing location is. And then from that chart, you should be able to identify whether you are, in the respect of each processing activity, acting as a data controller or data processor, because that's the key decision. Once you've got that in place, you know what your obligations under the GDPR are. And then this is where us boring lawyers also come in, is that you need to have some GDPR terms ready to negotiate your customer contracts and supplier contracts, because remember, it's all a chain of flow. So sometimes you might be acting as a supplier, other times you'll be acting as a customer, and the terms are slightly different clearly in each way. And it would be wise to have, or at least a guideline ready as to what it is you can agree to in each instance. Draft a data management policy. This doesn't have to be a huge, thick, detailed document. It can just be a bullet point, even setting out, this is the personal data that we process in the following, as a data controller or data processor. Talk about how long we should retain that data, what happens on termination of a contract, how do you destroy it, how do you return it, etc. So it doesn't have to be beautifully drafted in paragraphs and on beautiful paper. It can just be a simple Word document and bullet points, done, as long as it sets out your thinking and why you're taking certain decisions. And then lastly, consider DPO requirement, whether you should be appointing one or not, and why. And that's me done for the strictly legal bit. So as Aman said, Aman will be presenting the next stage mostly, but I think I'll be piping in now and then with a few legal bits. And this is me. If you have any questions, please feel free to get in touch.
Thank you so much.
Over to you, Aman.
Thanks. If you can pass on the control to me, and then I can become the presenter. Yeah.
Just done that.
Okay. So can you see my screen now with the slide, Rustam?
Not yet, I have to say, not yet. Although my screen is no longer being shared, I've got that confirmed.
Okay, let me just let me know when you can see my screen.
Sure.
Sorry. Um, I think there is some. Okay.
Got it?
So here you go. Yeah, got it.
There we go. Yeah, got it.
Okay, good. Thanks. Thank you, Rustam. Very, very insightful. Good knowledge sharing. I think you came across pretty well with the legal aspect of it, which we always struggle to understand. And let me just quickly now talk through the next few things, and specifically about the e-commerce. So this, I hope you can see this slide now, Rustam.
Yep, all good.
Perfect, good. So in e-commerce business, I think most of the people who are listening to this webinar are either you might have understood by now that either you are the controllers of the data or the processors of the data. So if you are owning an online shop, online store, e-commerce system, and then you are selling stuff to your customers, then you are pretty much the controller of the data. If you are a software development company, if you are a service company, those customers whose data we are talking about are not your customers, but you are still providing services to your customers, then you are pretty much the processors of the data. So in terms of the e-commerce applications and e-commerce ecosystem, we do have a lot of information and data which we store in our servers and databases, and some of it is related to the customers and some of it related to the products. Like the product pictures, product description, etc. And obviously, GDPR is nothing to do with that. GDPR is only to do with the customer information, and that to be the customer's personal information. Which, as Rustum said, could be the name, the address, telephone number, email address, etc., etc. And so that's what we are talking about today. In e-commerce, usually what we do is we collect information from customer. So whenever customer tries to buy anything or buys anything or register in a website, there is a registration page, and that's where you collect information. Usually, name, telephone number, email address, postal address, etc. Especially in e-commerce, obviously you have to send the shipment out. You have to send the product, so you also collect the home address or the postal address of the customer. In some cases, you are storing even the IP address of the customer in your system. So that's the collection part of it. And how do we use this data? If you are using nopCommerce based applications, all your database or your personal information is stored in the SQL Server database. And the only way you are exposing this data is through the application which your customers are using or your staff is using. But in so many other instances, you are also unknowingly sharing this personal information with third parties. So, for example, if you have an external CRM system, where the information, the customer information, is being synced or migrated to an external CRM system, which you might be using. And a lot of you must be sending emails out to your customers or campaigns and using tools like MailChimp, which means that you're extracting all the personal information from your database and then importing it into MailChimp and then sending that email out. And a lot of us, stored a copy of personal information or user data in various Excel sheets. Just use the export functionality in nopCommerce and have the Excel sheets of personal data. And then, of course, I think most of you are using fulfillment companies or the shipping companies to ship your product to the customer. You are passing on all the information to the third parties, the address, for example, name and address usually, and the payment gateway. If you're using PayPal, using the Stripe or any other WorldPay payment gateway, the credit card numbers, the telephone number, or essentially the name and credit card numbers are being passed on to the third party system. And then you send a lot of emails to all your customers. Some are related to the campaigns or the promotions, and some are just the communication you do send. And then there is a lot of information which goes out from the application itself. So when someone is placing an order, an email goes out to the customer. When the order is being shipped, the email goes to the customer. So there was a lot of initially when I was talking to a lot of my customers, there was a bit of a confusion that which information, what kind of personal information we should be talking about, and we should be controlling, and we should be making it safe, and how we deal with these kind of personal information being distributed to different systems. And my answer to a lot of question is that first you should know, that's the first basic thing, that you should know where the information is being shared and exposed, and the personal information. And once you have made a list of that, once you have made a process around that, then I think one of the hurdle is done. And then you start thinking about the consent, and two things basically. One is the consent, and the second is the legal obligation. So, for example, if you are sharing data or personal information of your customer with a third party, what is the legal terms you have between you and the third party? So, Rustam, I would want you to pitch in this and just tell us a little bit more about those legal requirements we might have to have in place for these kind of scenarios.
You're talking about in the contract between you and your subcontractors.
Yes, essentially. If we are using Mailchimp, for example, or if we are using CRM systems.
Well, in the contract with the CRM, for example, let's take that. So it depends where the marketing data is coming from, for example, or where the personal data is coming from. If you're just inputting data which you have obtained, then clearly you're the data controller. And in the contract between these service providers, you need to make sure there are restrictions on how they use that personal data. There are some obligations about what they will do to assist you when individual data subjects want to exercise their rights. And I think you're going to talk about that a little bit afterwards.
Yeah.
But there has to be quite concrete obligations. You need to talk about what they will and will not do in terms of appointing sub-processors themselves. So, for example, if the CRM is a cloud-based provider, they themselves will have subcontractors. They will have maybe data storage somewhere. You need to make sure there are certain restrictions in there about how they can do that or what they need to do. And also about the return of data and about the portability of that personal data, what happens with that. And then clearly you need to think about liability. You need to think about whether you are sufficiently covered under that agreement now with the new potential charges going forward if something were to go wrong.
Yeah, that's. I think there was few questions asked, which I will ask you in maybe next slide, which are related to this. But one of the question people asked is that we have a contract with a shipping company. So whenever we get an order placed on our website, we send this information to the shipping company to ship the order, which means that we give them the postal address and details and everything. And how would we protect ourselves that they are not misusing that data? They are not, selling this data to somebody else or start, sending their own campaigns to our customers.
Yes, which of course they would never do. But in the real world, unfortunately, the answer is clearly there's no way that you can actually guarantee that it never happens. So what you need to concentrate on is making sure you have contractual terms that say exactly that in that particular scenario, it would be likely they are the data processors, your data controller, if the direct relationship is with you and the end customer, and that you have exactly these sort of terms in that contract with them, that they will not pass the personal data on. They will only use it for a specific activity. You should investigate in relation, depending on what kind of subcontractor it is, you need to investigate where they store their personal data, whether ever there's a risk of it being transmitted outside Europe. And maybe if you have the resources, all you can do is think about having audit rights, personal data audit rights, where you go in once a year and just see how they actually work in practice. But clearly, that's something which only very large companies have the resources for. Most smaller companies just simply don't have the resources to go in and audit every single supplier. It's just not feasible.
Yeah, that's good. And there's another aspect of this, which is the security of the data transmission. If you look at the GDPR website, the ICO website, they have quite much sort of detailed how you should protect the information when it is being transmitted from one system to other system. So so my advice to all my customers is that ensure that that transmission is secure. For example, if you have a system of a CRM or a shipment company or any other third party. It has to be like a HTTPS. It has to be have that the data security in place, so the information is not leaked when it's being transmitted from your system to the other system. Especially if you're working with the payment gateways like PayPal and others, and then probably you are pretty much secure because all these systems are already protected and they have encryptions already in place. So your site obviously should have encryption in place, which is HTTPS or SSL certificate, which you usually install, and also ensure that the third party with whom you are sharing the data, they also have those kind of measures in place for the protection of the data during the transmission. And especially the Excel sheets, I think most of the companies, what they're doing is getting rid of data being stored in Excel sheets. So there is a lot of the cleanup being done these days in a lot of companies, and we suggest everyone to do that. Even if you need to store any information or data in Excel sheets in some form, then make those password protected, and don't just put them on the Google sheet or simple Excel sheets and floating around here and there in the company. Is that correct, Rustam?
Yeah, and I think it's worth mentioning very briefly, talking about security. Obviously, there are certain security standards that are out there, ISO 27001, etc., which and the PCI standards as well. Now, one thing to be very clear about, one of the myths is that there is some sort of GDPR certification out there. I've seen people try to sell that, but please be aware that currently there is no such thing. There is no one certification that if you obtain it and put a decal on your website or in your email footer, it'll automatically mean that you're GDPR certified, because it's an ongoing living process. That's the problem with GDPR. And specifically talking about encryption again, people think that the GDPR requires encryption. It doesn't. You might think, given the kind of processing activity that you undertake, that encryption is a good idea. That's your choice because you have made that judgment. But it is not a requirement. What it does do in the case of encryption is that in the case of a breach, a data loss, it means that the damage is minimized depending on how you go about with your keys, obviously. But on the face of it, assuming that everything with your keys is okay, it's damage limitation, but it's not guarantee of compliance.
Okay. Thank you so much for this. We move on to the next slide. So I think we have answered some of these questions which people have recently asked me. And one of those is obviously, people do ask that what should be covered in their terms and conditions, which usually they put on the website, and it's going to be different now. And what's the difference between T&C or terms and conditions and the consent? So I think that is the point where, depending upon your business, depending upon your business needs, you need to consult the legal people. You need to consult someone to ensure that the terms and conditions are covered in your and then they are visible on your website, and they are reflecting everything what we talked about, the data protection and the GDPR as well. Whereas consent is slightly different. Consent is very specific to what you're going to do with the data, where you're going to use that data. And then there's obviously a difference between your legitimate contractual obligations and for which do you need a consent or you don't need a consent. And then there is other communication you are sending out to your customers using their personal information, where you would need explicit consent. So in terms of e-commerce business, in my opinion, the legitimate contractual obligation you have is that whenever somebody places an order on your website, you will send them the confirmation. You wouldn't probably ask and consent that shall we send you the confirmation of your order or shall we not send you confirmation of your order. So for these kind of communications which you're going to send to your customer, in my opinion, I don't think you would need a specific or explicit consent for your customer from your customer. But if you are thinking of sending them like a promotional emails or a newsletters, etc., then probably that comes under the consent. Again, Rustam, I would want you to pitch in if any of this understanding is correct or incorrect.
Yeah, I think generally with consent, you want to stay away from using consent in relation to any activity where you actually have to continue it, where you don't want to run the risk of a data subject withdrawing consent and then being stuck halfway through, for example, a marketing campaign and having to think about, well, how do I remove that person's personal data? At the same time, consent can be used quite well if it's for very discrete purposes. So you could, for example, seek consent specifically to receive literature, marketing literature, because that is quite easy to, and it has to be opt-in rather than opt-out. That's also important, but it's easy to administer from your point of view. If somebody writes back saying, I withdraw consent for this, it's a case of then just making sure internally your systems pick that up and that person is no longer sent that particular communication. So that I would say consent is possible to use, but maybe not for other things. And the other thing to keep in mind for marketing is that there is also the Privacy and Electronic Communication Regulations called PECA. Until now, the requirements of the PECA and the Data Protection Act were kind of fulfilled by the same opt-in, opt-out thing in relation to direct marketing campaigns to individuals. But that is no longer the case going forward. So a simple opt-in, opt-out consent-wise, certainly an opt-out consent is no longer going to be sufficient for the GDPR. So if we were relying on opt-out consent for both going forward, that's no longer possible. I need to really look at how you manage that.
Yeah. Okay, thank you. So then I know I came across a number of questions about using the plugin which we have developed specifically for nopCommerce, and there are some customers who want some changes in the way the plugin works and how the front end front end works. So my answer to those questions is that this plugin is just a guideline. It is not going to, once you install the plugin, it's not going to make you 100% GDPR compliant as such, because you have to follow the whole process. The plugin just enables you to kind of introduce certain features within your applications, which will make you a lot more GDPR compliant. And we don't have much time left actually to do the complete demo, and we have done that demo in the last in the previous webinar. But I will send you some links and I will show you how it works in maybe next couple of minutes. So in terms of that plugin, which I talked about, what we try to do is to map some of these controls or some of these 6 goals, which Rustam just explained in the Article 6, to the features which we have introduced in the e-commerce application in the platform on the nopCommerce with the help of this plugin. So I'll just take you through to that plugin just spend 2-3 minutes on that. So if you go to this website, shop.tmotions.com, that's where this plugin is available. You can download it and install it fairly easy. And what you can also do is that you can see the demo and you see all the information regarding this plugin, which is down here. Which is like also includes how to install and how to use. Fairly simple. I think about 150 plus customers have already downloaded it and used it, and some of our customers have also purchased or asked us for the source code of this plugin so that they can customize it as per their requirement. The way we did it is that we build this plugin for the standard nopCommerce configuration. But most of your online applications and online shops would have been or might have been customized a lot, and there must be additional features you have already implemented. So in your case, the plugin might work slightly differently, and then you need to take the copy of the source code and then you have to change it according to your own requirements. So in terms of plugin, it's what it does is fairly simple. Is that let me just go to this one. And when you register here, after the plugin is installed, earlier they used to just fill in this information, which is the names, last name, and company detail and password, etc. So what we have done is we have introduced 2 or 3 more sections into this. One of the sections we've introduced is the text. So that's where this is just a sample text, but that's where you can explain to your customer or mention that why we are collecting this information, why we need to collect all this information from you. And depending upon your application, it could be a different set of applications. Some people might not want to ask for the gender, for example. That's fine. And so in this is not something which is coming from GDPR. This is just a sample text, but you can change it, modify it, using this tool. And that's where you can actually mention about the contractual obligation of sending the communication, to your customer about the transactions, etc. The other thing which is here is the consent. So in the control panel, you can set up what kind of consent you want to want your customers to allow or deny for the communication. So this is all managed from the control panel, and you can use this in the registration page. And once you log in, you go to my profile section, you can then manage all these things. And I'll just show you very quickly. If I possibly go back to the admin panel and log in as an administrator. And now in the admin panel, you will see this new section, which is GDPR. That's where, as an administration of your website, you will control everything, like the consent management, for example. All this text which you saw, you can manage from here, about consent. So this is a plain simple text. You can edit it and save it. I think most of you already know about it. Sorry, I'm running a bit fast because the time is almost over. But the other things you can do from here is that you can see consent by user, or you can select any user and see what consent he has sort of allowed or denied. And you can also here set the consent. So create a new consent. Yeah, at the moment we have like these two here, and you can just type anything and create, and then that consent will start appearing on your registration page. So these are the things which you do using this plugin, which is on the nopCommerce. The other thing is that if I go to the public store while I'm already logged in, and now if I go to my account, you will see these additional features on the left hand side on the menu. And these features have been introduced because we just have installed this plugin. So as a user, I can manage my consent here. I can say yes or no, or allow or deny to any of the consent. And what I can also do is, let's say, save here. I can also see the consent history, which is very important for us to manage. So on which date, what time I have given the consent for a particular thing, or have denied the consent. So you can see all that. You can also see the communication from this store here. So whenever this store has sent you any or your application has sent out any email automatically, which is about the placing an order or reminding password, etc. So all that can be now visible to the customer. We also have made a feature where you can also show the communication you have been sending to the customer, not from this application, but from the third parties. And if you go to the control panel, you can see how you can possibly manage that. And another important feature which we have introduced in this, which is the right of erasure in GDPR, is that a customer can just click some buttons and ask the store owner to delete the personal information. So which means that once you do it, it will what it will do is it will just update the database and delete the personal information, which is about the name, address, telephone number, email address, postal address, etc. But it wouldn't do is it would not physically delete the record. It will still keep the ID and the other transactions, etc. Which is very fine, because as per the GDPR, the only data which you should we are talking about here is the personal information. So on this demo, I would suggest that just play around with this and see how it works. Create a user, see all those options and play around with these options, and then possibly you'll get a lot more information about it. So once again, the site where you can see this is the shop.tmotions.com, which is up here, and that's where you will see all this information about this plugin. So I think if anyone need more information or a demo of this plugin, please feel free to contact us, and we'll be happy to do that. Let me see if anyone has asked any question which we have to answer now. There is one which is it possible to receive the slides? Asked by someone. So yes, we will be sharing the slides, and we will be sharing the recording of this webinar to all of you, and then you can play it again and see it again. And what I'll do is in the response to all of you, I'll put the links to some of the websites, especially this the plugin website, as well as the ICO website, where you can actually find a lot more information about GDPR and prepare yourself. So closing remarks. Thank you very much, first of all, for to all of you for your interest in this and attending this webinar. And I hope that you got a lot more information today. Today, probably the information you got is specific to the legal aspects of it. So that is something I think I'm really thankful to Rustam for that. Rustam, before I pass on to you to say your closing remarks, there's one more question just came up, which says, "Hi, we are the publisher, so the product has an author with the personal info in our database. How is that affected?" So, Rustam, maybe what I'll do is I'll send this question to you, and we can then reply to this question or offline. I think it's a slightly different, conversation.
Yeah, I'm not quite sure I understand it, but yeah, absolutely. Let's see if we can address it offline. That's fine.
Yeah. So you want to say just closing remarks, Rustam?
Yes, I would say thank you for your interest, first of all. It was really, really delightful to speak to you all. And the other thing I would say is don't panic. Regardless of everything out in the media, the regulator is not out to get you. It is out to get people who are really careless, negligent, and willfully in breach of this. That's who they're out to get. They want to establish a better culture. So provided you're not actively trying to be in breach, you can show that you're trying to be in compliance, you are doing well.
Great. Yeah. All right. Thank you so much, Rustam, and thank you, everyone. I'm signing off now, and if I will receive many questions and queries, then possibly we will do another session, another webinar in the next few weeks. Thank you all.
Thank you.